People against Alexander Sheedy. 5G306426. A, B, and C. Good morning, Mr. Camilleri. Your appearance?
Good morning, Judge. Kenneth Camilleri on behalf of Alexander Sheedy, Your Honor. I'm here with Mr. Sheedy. I'm here with Mr. I'm sorry, Judge.
That's all right. That's okay. Mr. Sheedy, your name?
He is not present, Your Honor. He is currently in school.
Oh, okay. So you're authorized to enter this plea on his behalf, right?
I am, Your Honor.
And he's going to plead, there's going to be a plea to file A, selling or furnishing alcohol to a minor. That's a civil infraction. And the prosecutors agreed to dismiss files B and C. True?
That is correct, Your Honor. Just for a point of reference, Your Honor, at the time and date of this incident, Mr. Sheedy was a bartender at River Billy's. So I don't want the court to think that he was furnishing alcohol at a house party or something like that.
I get it. All right. So to that charge, selling or furnishing alcohol to a minor, this would be on April 19 to 25 at 9:32 p.m. Count one. How do you plead? Responsible or not responsible?
Responsible, Your Honor.
I'll accept the plea. Dismiss files B and C. 205, pay by May 29th. How you been doing?
I've been doing great, Your Honor. The only request, Your Honor, may I give Mr. Sheedy 2 weeks, or may the court give him
That's fine.
2 weeks
June
to
5th. June 5th.
Yes, Judge. I'm doing well. How about yourself, Your Honor?
Good. Just getting older and uglier, but other than that, everything's good.
Well, I don't know about the uglier. You seem to be holding on pretty good.
Take care. Good to see you. Thanks.
See ya.
Olivia Keats. Olivia M. Keats, 24I-715-138. Good morning, Ms. Keats. Your name?
Olivia Keats, Your Honor.
You have a multitude of violations here. Failure to attend the scheduled probation visit on April 29. Failure to attend your scheduled probation visit on May 12. Failure to submit the biweekly testing on March 25. And failure to submit the biweekly testing as ordered on May the 5th. Do you understand all the charges?
Yes, Your Honor.
If you plead guilty, if you're found guilty, that would be 4 technical violations. You have 2 priors. Your probation could be revoked. You could be incarcerated for 93 days. Do you understand that?
Yes, Your Honor.
And did you sign, read, and understand the advice of rights?
Yes, Your Honor.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes, Your Honor.
All right, so you have the right to a lawyer. I presume you want one. Do you want a lawyer?
No.
Are you sure? I mean, it's up to you. I don't want to, you have the right to represent yourself. It's entirely up to you.
I don't want a lawyer.
All right. Is the count 1 that you failed to attend your scheduled probation visit on April 29th at 25? How do you plead?
Yes, Your Honor.
Is the count 2 that you failed to attend your scheduled probation visit on May 12th, 25? How do you plead?
Guilty.
Call Emily, please. Call Emily. Did you fail to attend your probation visit, count 1, on April the 29th?
Guilty.
Did you fail to attend your probation visit on April 29th?
Yes.
And did you fail to attend your probation visit on May 12th of 25?
Yes.
Is the count 3 that you failed to submit the biweekly chemical testing? How do you plead on March 25th?
Guilty.
Did you fail to submit on that date of March the 25th?
Yes.
And is the count 4 that you failed to submit the testing on May the 5th? How do you plead?
Guilty.
Did you fail to submit the testing on that date?
Yes. Your Honor,
Wait 1 second. Has anybody forced you to plead guilty?
No, Your Honor.
I'll accept your pleas. What are you doing?
Your Honor, if I may, I just want to point out that I've never been positive for a drug test. I went the next day. It was because I was at work, and I went straight the next day and it was negative. For my probation meetings, yes, I did miss them. I tried my best. The last time, I literally had my alarm, I was at work, it was a rush.
Where do you work?
I called her 30 minutes later.
Where do you work?
I worked at Burger King, Your Honor. Same as well, last time, doing good, so.
Well, wait a minute. I can appreciate the fact that you were negative on some tests.
All of them, Your Honor.
Well, but you weren't there March 25th, and I want you to understand, if you miss a test, I'm gonna make an assumption. It's gonna be that it was a positive test. You have to get there. You're testing the DNA, right?
On site in Lincoln Park.
Well, what times are they open?
4 to 7. And mind you, I work, sometimes I work in the mornings, sometimes I work in the afternoons. And the colors are random, but if I have to miss work, I'll just ask them to leave, Your Honor.
You're what?
I'll ask them if I can just leave, because it's more important to make it there than.
Did you finish your treatment?
Oh, yeah, my community service hours are done, my court work hours are done. I've been going to therapy every week. I'm supposed to be going to therapy until I get off probation, and I've been going. My whole treatment's pretty much done, except for my therapy.
I want to be understanding. You're going to have to tell me more. You call in the morning, right?
Yeah, the color, yes.
Right. So when you know you have to test, why aren't you tested? I'm still not following you.
Oh, it's because I forgot the one day.
Well, we can't forget these things.
It was the one time.
Your name?
Emily Casino?
What is going on here?
I don't know, she seems to do this every month. She called me to reschedule because of work, I rescheduled it, she missed, I rescheduled it again, she missed. And then she did call me, but, you know, I have other appointments and things.
I don't wanna be a wise guy. How old are you?
I'm 21, sir.
We have to be responsible in this world.
Yes, I know. That's what I'm trying to be.
We can't forget.
I know.
Do you have a phone?
Yes,
You put it on your calendar?
yes,
And you know you need to call for testing every morning, right?
yes. That's what I've been doing since then. Mostly my whole probation, just a couple times I've missed. Well, I'm thinking, Your Honor.
You got 6 violations. I mean, really. I don't know what to do with her.
Everything is done with the exception of maintaining her testing and her treatment. I do have her April letter, she did have good attendance. We've, you know, had some bumps with that, but for April, she had perfect attendance, so I'll give her credit for that.
Listen, she's saying on-site only has testing 4 to 7, is that true?
Yeah,
In the morning, they have it 7 to 10, and then they have it again 4 to 7.
Right.
And the weekend.
So wait a minute.
they only have the
So
morning.
why can't you make one of those tests?
I have no ride in the morning. I don't have my license because of my thing, and my nana can't take me that early in the morning. So
Where's Burger King? The one that you work at?
in Lincoln Park,
Where's on-site?
closer.
Closer to your work than it is your residence, isn't it?
No, I live in Wyandotte. So yeah, it is closer to my work.
Right. On-site's in Lincoln Park, right?
Yeah.
How far is Burger King, the one that you work at, from on-site?
Probably like 10-minute drive, so like an hour walk.
Hour walk? What street's on-site on again?
I think the address is 1570 4th Street.
And where's the Burger King?
On 4th Street.
They're both in Lincoln Park. You can't be an hour walk.
I just said that because that's like, I go to the gym and it's like an hour walk. It's still like a 10-minute ride. so
Listen,
just thought it would be
listen to me. I can't solve your problems. You're gonna have to solve your problems.
Yes, Your Honor.
It's nice enough now where you can take a bicycle. I don't know what to tell you.
Yeah, that's what I've been trying to do. It's starting to get warmer. I just got my.
I'm telling you, don't miss again.
Okay. Yes, Your Honor.
You can't keep missing testing. How often we got her testing? Bi-weekly? Still?
Yes.
How long's that going to last?
Until an operation in 4 months, Your Honor.
She's got a case too in, I believe, Wyandotte. So that's why
What's
we.
that for?
her on bi-weekly.
Okay.
I think that one is. Let me see if it's on her criminal history.
Listen. I'm gonna go light on the costs. I'm gonna keep you on probation. You have 6 total violations. You could have your probation revoked. I'm not gonna do that.
Thank you.
You pay additional costs of 50 and you're gonna do 10 hours of community service by June 15th. And I don't wanna see you back here on these. Do you understand?
Yes, thank you, Your Honor.
Do you understand?
Yes, Your Honor.
Do you fully understand?
Yes.
I don't wanna hear any more excuses. Can you pay the 50 now or do you need time?
I can pay the $50 now.
Come on. 6 violations. This is not do if you think you feel like it. It's, I have to do this. You understand?
Yes, Your Honor.
Good luck. Thanks. Thanks, Mr. Sino. Did I address everything?
Yeah.
Thank you.
Thank you.
Jackson in here?
Yes.
Elijah Jackson? Elijah Christopher Jackson, 25T645354 A and B. Could I have Alexander Parsons seated at the table and Maya Bailey seated at one of these tables? Sir, your name?
Elijah Jackson.
All right, so he's, counsel, your appearance?
Good morning, Judge Mezzanine, for Mr. Jackson.
He's going to plead guilty to allowing an unlicensed driver to drive. The defective equipment will be dismissed, true?
Yes,
Is
Judge.
that what you want to do?
Yes, sir.
If you plead to that, the possible penalties are up to 500 fines, 90 days jail. Costs are all those, 0 points, won't get reported to the Secretary of State. Do you understand that?
Yes, sir.
Did you sign the advice of rights and read and understand the rights?
Yes,
If you
sir.
plead guilty, you'll be giving up all those rights and there will not be a hearing or a trial. Do you understand that?
Yes, sir.
All right. And you want to plead to this charge of allowing an unlicensed driver to drive, correct?
Yes,
To
sir.
that charge, how do you plead? Guilty or not guilty?
Guilty,
Were you
sir.
in control of an 2004 Mercury that was being operated on April 4th, 25 at 11:20 p.m. on Van Horn near Lathrop and Trenton?
Yes,
And
sir.
were you unlicensed?
Yes,
Are
sir.
you on probation or parole?
No,
Anybody force you to plead guilty?
no.
Please accept it to that charge. The drive while suspends dismissed pursuant to the agreement of the parties as well as the defective equipment. Anything you want to say, counsel?
Nothing.
Sir, anything you'd like to say?
No, sir.
100 fines, 70 costs, 75 victims' rights fee, $50 justice assessment, 40 in attorney fees, 335 or 45 days. Can you pay all that now?
Not today.
How much
sir.
do you have today?
Like $100, sir.
Okay, you pay 100 now. How much can you pay per week? Can you pay 50?
You pay $50 a week?
Yes, sir.
Where do you work at?
Meyer, sir.
Okay, pay 100 now. You pay 50 per week. I'll begin that on June the first, let's see. Should be the 2nd, right? That's the first Monday, Lisa? In June?
Yes, that's correct.
Pay 50 a week starting June 2nd, okay?
Thank you, sir.
$100 today. I wish you well. If you ever need more time, you come talk to me. I'll be glad to give you an extension. No problem. Just don't ignore me, okay?
Yes, sir.
Good luck. Parsons. Alexander Salim Parsons, 25T645346.
Good morning, Judge Mezzanine, for Mr. Parsons.
Yeah, this is what should happen. Your name?
Alexander Parsons.
You just didn't have his license on him?
Yeah, you just didn't have it. It's still, it's valid.
Yeah, I got it. Case dismissed, motion to prosecutor. That is what should happen. Good luck.
Thank you, Your Honor.
Thank you.
No.
Maya Bailey, 25G306372A and B.
Good morning, Judge Mezzanine, for Mr. Bailey. State your name for the record, please.
My baby.
All right, what have we got here?
Just asking for a discovery, Judge.
First of all, does she stand mute and waive formal reading?
Yes, Judge.
So we've got an assault and battery, and we've got an aiding and abetting a minor. So I'm entering not guilty pleas on those. I'm signing the discovery order. You're going to have to fill out a petition for a court-appointed lawyer if you want one going forward, okay? Do you work, ma'am?
No,
Okay,
I'm in school right now, though.
where do you go to school at?
For priority health, it's for a CNA class. It's for 3 weeks.
Okay. gotta tell me who the victim is. I got no idea. What's happening at Shoemate? Don't you answer anything. I need Detective Robinson. Will you call 249?
You stepped out, Your Honor, she's gonna try to find.
Don't worry about it.
Yeah, make sure you're done to fill that out.
I'm gonna give you $1,000 personal bond. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. You're not to have any contact with the victim. You cannot write, phone, see, text, email, or communicate with the victim at all. And you can't have anybody else do any of those things for you or on your behalf. No contact with prosecution witnesses. No contact with prosecution witnesses. You're not to possess firearms or dangerous weapons. These are all conditions of your bond. And you have to go over and get fingerprinted and photographed by 1 p.m. today at the Gibraltar Police Department. So again, no contact with the victim or prosecution witnesses. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. And I am going to give you a court date. You're going to fill out your petition. You're going to go down the hall. You're going to get your notice. You're going to get your bond sheet. And you're going to take your order for prints and photographs over to the Gibraltar Police Department. What do you have, Lisa?
June 9th at 2:30.
So June the 9th at 2:30 is going to be your court date, okay?
Judge, can she do it by Zoom? She has school, correct?
Yeah.
She has school.
Oh, wait, no, actually, that's 3 weeks. I'm good.
Okay, all right.
June 9th, 2:30. Yeah, I'd like you in person on something like this, okay? We'll see you here then. I wish you well, but don't leave until you fill out that petition and go down the hall and make sure you go over to Gibraltar and get printed, okay? Joseph Matthew Kimes. Joseph Matthew Kimes. 25G306319. Is he here?
Yeah, they're on Zoom.
Okay. Good morning. Mr. Buhanis, your appearance?
Good morning, Your Honor. Greg Bulahans, P36431, on behalf of Joseph Kimes.
All right, Mr. Kimes, your name?
Joseph Kimes, Your Honor.
All right, so he's got a 256. Wow, these guys, all right, anyway, have you had a chance to review the screening and assessment report, and are there any material additions, corrections, or deletions?
There are no material additions, corrections, or deletions, Your Honor.
What's this? Yeah,
He has been attending AA 3 times a week.
and you've seen that?
Yes, I have it right here.
Okay,
I looked at it before we started.
good enough. What else?
Your Honor, the other thing is he's in the reserves and we had talked about this. We were in person last time. I don't know if you recall about he's going to drill in June at the end of May for a couple weeks and so forth. I don't know if you want him to discuss that with probation or we should bring it up here now.
When's he gonna be gone?
What's your dates? Hold on 1 second, Your Honor. He has it on his phone.
I got some concerns here about you, Mr. Kimes. To be candid with you,
20th of May to what? May 28th through June 11th, Your Honor. And I did talk to him about this as well, and he does get, whenever he goes to drill, they do test them. How often do they test you when you drill?
Yeah, I've never been with them.
Your Honor, he has no priors.
I know, but he's got over three times the legal limit. Jeez.
Yeah, well, this is what happened, Your Honor. He made a really bad decision. He was on a party bus and, for whatever reason, instead of just taking an Uber from wherever the party bus ended up, he ended up driving his vehicle. How far was the vehicle from your house? About 10 minutes away. He made a bad decision on that day. But, he's been in the service for 8 years, 12 years, and he's going to continue in the reserves, Your Honor. He's been a model member of the community other than this one incident. And Your Honor, I think he doesn't have anything else if you look at a CCH.
No, I know. I didn't say I was sending him to jail, but.
No, I know. I'm just saying he understands the significance of this. I've had many talks with him, and he's gonna be testing. He hasn't, had any issues. He's been doing the AA as you ordered. And I think, Your Honor, he himself has jeopardized his future with the reserves and his pension. He has, this particular incident is going to cost him, a lot of money. And I think it's a wake-up call for him. And there is a chance that he may not be able to re-up in the service in September. So he was, he's trying to get back into the reserves, re-engage in September, correct? Or is it October? October, I'm sorry.
All right. Anything?
So he is, serving the country, and he served it for the last 12 years. And
I like the way you said that, Mr. Boulahanis. Right. I mean, I admire anybody in the service. I really do. Without a doubt.
Yeah, I think this is I think this was a binge drink. He's on a party bus. It's a binge drinking event.
I get it.
And he made a horrible decision.
I know. All right. Anything you'd like to say, Mr. Kimes?
No, Your Honor.
All right. 14 months probation. I was almost ready to order a sober link on this. I probably should. I won't. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You can leave the state between May 28th and June 11th. You can, if you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no illegal drugs, no marijuana. You're not to go any place that sells or dispenses alcohol or marijuana or illegal drugs. Submit to chemical testing, PBTs and ETGs. I'm going to make it weekly for 3 months. If you're clean, bi-weekly for 2. If you're clean, then monthly. Attend AA, NA 3 times a week until you're in an intensive outpatient treatment program with aftercare. Once you get in intensive outpatient treatment, you no longer have to go to AA or NA. Attend the Victims Impact Panel, serve 4 days jail credit 1. I'll let you serve 3 days on the court work program in lieu of jail. There's $105 in court work program fees. Pay fines $300, cost $200, $75 victims' rights fee, $50 justice assessment, that's $6.25. Screening fee is $60 for $685. You have $280 in probation fees, so your total's $965 plus the court work program fees for $1,070 plus cost of recovery of $225. Everything included is $1,295. If you violate, your probation could be revoked. You could be incarcerated for 93 days. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. And I want you to understand also, if you're clean and do everything, you may be eligible for early discharge. You can get off probation in 7 months. Do you understand that, sir?
Yeah, the only issue is I'm going to ask you, so he should reach out to the probation officer if he gets orders for further deployment after the one that we've just.
Oh yeah, I mean, if they're reasonable about it, but they're going to probably, if it's for he'll tell probation, they'll give him direction depending on.
Okay. And did you want him to report to probation today, Your Honor?
I would, but why don't you? Is everybody?
Or do you want him to come in maybe another day?
Emily's the only one there.
Call over to Pam, Tabitha, and see if today's a good day for Mr. Kimes to come here, or tomorrow would be better. And Sir, can he pay all of this, Mr. Blumanis?
Your Honor, can you pay it off?
Your Honor, you take card, correct?
Yeah, yes,
I didn't hear what he said.
credit card.
Oh, yeah, we take a credit card. Did somebody,
Yes, Your Honor. Okay.
1 week.
so give me 1 second. I'm having them call over and find out when they want them. Apparently, there's 2 probation officers out. So I don't know if they're gonna want them today or tomorrow. What are they
Your Honor,
telling?
Can he have until, a couple days to pay it?
Yeah, I'll give him a couple days. Is that all he needs? May 27th?
Yeah, that's fine, Your Honor.
827, okay.
That's
Just tell,
fine, Your Honor.
yeah, just ask them if they're better off coming in today or tomorrow. That's all I want to know.
Yeah.
What,
Today's good.
yeah, come on up here today, okay? And you'll meet with probation today. I
You want
was,
him to wait till afternoon, Your Honor, or right now?
I mean, I could carry, just not, we don't want him walking in at 3:45.
No.
Sometime, as long as he's here by 1:30 or so, that's best.
Okay, thank you so much.
Have a good day. Good luck to you, sir.
You too. Thank you, Your Honor.
Thanks for your service. All right, what do we have? Anything else? Stay seated.
Court is back in session.
People against Wagrecki. Kathleen Ann Wagrecki, 21T707073. Your name?
Good morning, Judge Massengate, and Mr. Werki.
All right, so what are we doing on this one?
Judge, it says sentencing. But I've looked at the ROA, you already sentenced Mr. Werki back in 2001.
Yeah, I know.
Probation order in the file,
I know, but I revoked her release, forfeited her bond.
back in January. But according to Mr. Werki, you sentenced her to drug court at that time.
I tried to help her. She didn't want to help. She didn't want to have any help. Let me just check something.
Sure.
Lisa, I believe I revoked her HIDA status.
Yeah, and January 3rd, and then you wanted her screened again.
Yeah, and then I set a sentencing date for January 24th. I tried to talk to her.
Then she didn't appear.
Correct, January 14th. Failed to appear for chemical test and subsequent failed to appear for probation appointment. January 13, revoked her release, forfeited the bond pending a hearing. So, yeah, when I revoked the HIDA status, it's time to be sentenced anew. So, first of all, she can explain to me and to us why she decided just not to show up.
Sure.
I'm gonna be completely honest.
No,
Yeah. In January, I was still on drugs
you're kidding.
and I wasn't taking anything serious.
Oh, jeez, that's too bad.
And I recently, in March, I got off all of my prescription medications.
You what?
In March, I got off all of my prescription medications. One was a narcotic, and I had been trying to be and stay clean since March. And I just got a job recently when I got out of county, and I want to put this behind you.
I wanted to be president. I don't know what to tell you. I'm not real. You cannot, don't throw those crocodile tears at
I'm
me.
not trying to, I'm just scared. And so
Well, you should be scared. You should be scared. You have been not a very good mother. Okay? I tried to help you.
I know you did. Thank you for.
You didn't want any help. If I gave you another chance, you still wouldn't want help. No,
Please give me one more chance.
no, 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 no. I begged you. I remember this woman. I begged you to turn your life around, to try to be a good mother. We would try to help you, get you into sobriety / drug court, and you wanted nothing to do with it. You wanted absolutely nothing to do with that. So please, save it for somebody else. If I sound harsh, I'm not apologizing. You ought to be ashamed of yourself. We have children we bring into this world. And the main reason the world's messed up like it is because a good percentage of people are just simply lousy parents or don't care or a combination thereof. We don't leave our children with our mother. That's not who they want raising them, and they're a lot more smart than we give them credit for. I don't care if they're 19, 9, or 9 weeks.
Yes, Your Honor.
Give me a first page of a register. I mean, I remember having this conversation with you and your mother. And I gotta tell you, sometimes I know I'm spitting into the wind. I know it. I know it. I know I'm spitting. And sometimes it's like a 75-mile-per-hour wind coming back at me. But I don't want any regrets. I want to give everybody an opportunity, and I don't want taking anything that I did to my grave with me or dealing with my conscience as to why I didn't help. And I begged you. How many days credits do you have coming?
Judge, I believe there was already 3 days in the file.
Yeah, I know. Who was your probation officer again? I need Emily on this. Bring Emily in here on this.
Judge, the mother would like to address the court.
I don't know why.
She's the victim in this case.
I know she is. Come on up here. Yeah, but she's, come on up.
All right, thanks.
Yeah, just move back.
She's on the way.
How old are you?
27.
Your name?
Choice of Hammer.
What would you like to tell me?
Your Honor, I've been through a lot with this child. And I've tried everything. I even pleaded with you to help me get her help, to get her straightened
We
around.
tried.
And
I only have so many resources here.
I definitely understand that. I want you to do what you feel is best for her, to get her straightened around. I am raising her 2 kids.
I know. You were then, you have been, and you're going to for the foreseeable future.
And me and her father are doing the best we can. I don't know nothing about jail. I don't know if it's good, bad.
I don't think any of us want to visit there.
No, I don't.
I mean, I remember going in there when I was a lawyer, and I couldn't stand going in those little cubicles with those guys. Their breasts stunk, they stunk.
And I will not take my grandchildren there to see her if that's the case.
Your name?
Emily Tessino.
You got anything to say on her?
I haven't seen her since she showed up for her bond conditions, and she didn't do one thing.
Yeah. Lisa, do you have, how many days credit does she have coming? Can you tell me? Well, I don't listen to anything you have to say, Mr. Gay.
I'm sorry, as far as credit, I know she told me that she was incarcerated she just got out, I believe, on Tuesday. Incarcerated for 5 days.
Yeah, in my case, I arraigned her on May 16th. When did you get out?
First day, Your Honor.
Today's the
Today's the 22nd.
So she got out the 20th. So she's got 5 days credit coming from that. And she's got 8 days credit total coming, I think. I don't see anything else. They're gonna cancel the bond conditions out, Lisa. I begged you. I remember this one. I'm not gonna feel sorry for you. What has she got, 8?
That's all. I do remember she was in custody when she got referred for sobriety court, but I don't see anything in the file to tell me how long she was, if I'm honest. So I don't want to guess.
How much does she owe, Lisa? Can you tell me?
600.
She can have that paid today, Judge.
Sometimes people force us to do things we don't want to do. You need to straighten out your life. 200 fines, 300 costs, 75 victims' rights fee, $50 justice assessment, 6 1/4 in 60 days. You'll pay 30 more, or you'll serve 30 more if you don't pay your fines. Credit 8. So she's going to serve 52 days. If she pays her 6 1/4 today, you have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. I wish you would have listened to me. Good luck. Have a seat.
No, you're gonna have to see it right here.
Before we get started, there's one anti-harassment petition we're going to take up, and then we'll start the regular calendar. Mr. Huntley, can you come on the Zoom call there, please?
I'm here.
Hi there.
Hello. Good
So
morning.
I've reviewed your petition. So have you gone a few years without hearing from this particular individual?
It's been about a year since I've had any kind of interaction with them.
Okay.
And
so, go ahead.
Excuse me, just up until this last Tuesday.
Okay. And then tell me again what happened this Tuesday?
They reached out to me from a number I didn't recognize, and I answered the call. And he told me who he was. I basically told him he had the wrong number, and then hung up. But
Okay.
it's troubling because it's going to be the second
But
time.
you didn't communicate with them or talk with them or anything like that?
No.
All right. So what's going to happen today is I'm going to set it, I'm not going to grant a temporary order, but we will set it for hearing. He'll need to be served with the petition. We're going to set a hearing within 14 days of today's date. Today is May 22nd. So we're going to set a hearing for June 2nd. And then he'll need to be served with a petition. You provide an email where we can send you the notice of hearing and petition for service?
Yes.
A copy of that will get sent to you. You'll need to get him served. And then that can be anyone but you. You can hire someone to do it. You can have a mutual acquaintance, hire law enforcement, hire a private server to do it. However you want to do it is fine. But he'll need to be served. We'll reconvene on June 2nd. And then a judge will hear from both sides to determine whether or not the order will be entered and go forward.
Okay. Thank you very much for your time.
That's it. And you're free to go.
Thank you.
What case are you for? You here for there, Mr. English?
Martin Torres. I filed an NOA on Monday, but the docket still does not reflect that.
Okay, so he's in custody.
Correct.
Okay. And I don't have any control over when they're called, so we'll just have to wait.
I'll just be hanging out.
Okay, unless there's something that can be done today. It's on for pretrial.
The plan is to ask the court for entry into a deferred prosecution.
Okay, then we'll wait. That's fine. At Nisqually, what's your name in the orange shirt there?
Trevor Doran.
And Ms. Langley, are you here with Mr. Doran? Or no, Mr.
This is a state's case, Your Honor.
City of Tumwater. Okay, yeah, I see. He's got 4 backups for Lacey. I see. I guess I just didn't go far enough. Mr. Pizderka, you're here for the City of Tumwater theft case?
Yep.
And give me just a second. Mr. Pizderka, did you get a chance to speak with him regarding his legal rights?
Yes, Your Honor. We've heard the advisement formal reading of the court under a not guilty plea on behalf of Mr. Doran, and we are asking for our office to be appointed to represent.
And then do you have a position on probable cause?
Sorry, no objection to probable cause for purposes of this hearing.
So Mr. Doran, in the Tumwater case, you're charged with 1 count of theft. And that's a gross misdemeanor, which carries with it a maximum penalty of 364 days in jail and a $5,000 fine. To that charge, a plea of not guilty will be entered. This matter will get set for future hearing. We're going to set conditions of release in the Tumwater case. You're also here on 4 different Lacey cases, which is now alleging non-compliance with their probation in that you're now charged with a new crime. So what's going to happen is I'm going to hear from the city of Tumwater on conditions of release on the new charge. Then I'll hear from the city of Lacey. Then I'll hear from Mr. Pazderka on the Tumwater charge. And Ms. Alt, are you here on the Lacey cases?
Yeah, yes, Your Honor.
And then I'll hear from you, and then I'll require that you be on screen when the time comes.
Yes, Your Honor.
Mr. Weston, what's the city's position on the city of Tumwater?
The city's asking for $1,000 bail with conditions of no new law violations and to stay away from Tumwater Safeway located at 520 Cleveland Avenue Southeast, Tumwater, Washington. The basis for the bail is that 2 active warrants from 2024 and some other FTA history from 2024 and 2023. The state has concerns about whether the defendant will appear in future hearings, and based on the fact that we're here for there's several Lacey backup matters. The state has concerns about whether he will abide by any conditions of release.
Mr. Sharp.
Sharp, I apologize. It cut. You cannot hear.
So Mr. Sharp, I can't hear you.
Sorry, Your Honor, can you hear me now?
I can.
Sorry about that. City's moving to revoke probation based on its 4 cases based on the new law violation. We're requesting $1,000 bail on each pending PFTC. As Mr. Weston pointed out, those 2 active warrants are a cause for concern. City doesn't believe he's likely to reappear without bail.
Mr. Pazderka, I'll hear from you first.
Your Honor, given the Lacey cases, their requests, and given the timeline at issue, our request would be Mr. Doran be released on his own recognizance. However, in the alternative, that bail is imposed, we would ask that it be nominal. I spoke with Mr. Doran, he does not have financial capabilities to post even $1,000 bail. So knowing that he potentially would have bail imposed on multiple of these cases, and his limited ability to address or post that bail, we would just ask that any bail imposed in the state case be, or the Tumwater case be nominal.
And Ms. Alt.
Your Honor, in speaking with Mr. Doran, it sounds like he's currently residing with Union Gospel. He hasn't been able to work for the last 2 years due to the fact that he has this criminal history. I haven't seen the police report for the Tumwater case, but my understanding is the allegation is that he was allegedly stealing food, which sounds like a crime of necessity to me. His last crime here that he's on probation for in Lacey was for almost a year ago. It looks like the court recently imposed a sanction of 104 days. I don't really know what we're doing here. At this point, he's willing to stipulate to the new law about behavior violation if we can just impose a sanction and close out these probation cases. It feels like we're punishing someone for being homeless and not being able to afford food.
Mr. Sharp, on a stipulation without admission of guilt on the Tumwater case, what's the city's recommendation as a sanction?
Thank you, Your Honor. I hadn't anticipated that. 2 of these cases would end in 3 days based on age, not counting for warrant time. Well, 3 of the 4.
Which ones are those?
That's all but the theft. The theft case has quite a bit of jurisdiction on it.
Okay.
At this point, given the number of cases here, as well as his repeated behavior, city would recommend 20 days with EHM authorized as a sanction, and city would object to closing any of these. We think the deterrent's still important.
Well, the case ending in 3 days, those will close, won't they?
Right. Well, in 3 days.
Well, if he gets 20 days, then it'll be closed by the end of it. Ms. Alt, your response to what?
I mean, I
Mr.
guess he's probably going to be in there for the next 20 days anyway, if he's held on the new matter. So I think that's reasonable if we can just, although I would request that we close these files. I don't know what the city is trying to accomplish here.
Give me a minute. And he's in Nisqually, so he'll probably get heard by Olympia here before too long. So in the theft case ending in 422. Yes, well, actually, hang on just a second. Yes, 206 days still suspended. I'll reimpose 206. I'll suspend 186 for 20 served. So have 20 to, well, with the credit for 19, I guess, or credit for 1 with 19 left to go. On, and then all conditions remain. So he'll start serving time on that. Given that there's only 3 days of jurisdiction in the other cases, those will all just be closed out.
Yeah, if I could, one additional consideration, we have a no contact order in the assault case. Granted, it would expire on its own in 3 days. However, we haven't had time to notify the victim that it could expire early if the court closes the case.
Ms. Langley here on, which one is that case? Is that the case ending in 814?
That's it, Your Honor.
Give me just a minute. If it was gonna expire in 3 days, was that on your schedule to contact her within the next 3 days?
No, Your Honor, but it's on the copy of the order that she'd have, the expiration date.
Okay. Okay, give me a minute. On the Tumwater case, ending in 490, bail will be set in the amount of 1,000 cash or bond. Conditions that's posted, not to have any criminal law violations. Don't have any contact with the Tumwater Safeway. I'm setting a pretrial for June 4th of 20. It won't set it right on the in-custody calendar. So if you make bail there, Mr. Dorn, you still need to be here at 1:30. On that case, on the case ending in 187 from Lacey. He'll be PR'd on that. He'll be released. On the case ending in 814, he'll be PR'd on that case with all prior conditions remain. And then that no contact order will just expire on its own by Monday. So the only thing he's going to be held on is the Tumwater theft, and that's on 1,000 cash or bond. And actually, he'll be serving the 20 days on the other cases as well. On the other case, I should say.
Your Honor, I apologize.
I'm sorry?
If you had already stated this, I apologize, but I just want to clarify that our office is appointed.
Yes, if I neglected to say that, I apologize. Thurston County Public Defense is appointed to represent you. It's on a week from Wednesday. Just let your office know. Maybe it can be resolved at that time. And Mr. Doran, you can be taken back. Ms. Moore, who's seated next to you?
Your Honor, this is Mr. Rodriguez, and his matter was actually moved to the 135, but he is still in custody because they were waiting on a DCR review. I believe the state has a motion on this matter.
Mr. Weston?
Your Honor, the state's moving to dismiss without prejudice pending talks.
So he'll be released without conditions. And this could be refiled at some point, Mr. Rodriguez, but for today, you'll be released.
Thank you, Your Honor.
All right, thank you.
You're welcome. What's your name and Nisqually there?
Sarah Blankenship.
Could you say that again, please? A little
Sarah
slower?
Blankenship.
Oh, thank you. Who's on for a warrant? And then Ms. Alt, you're here with Ms. Blankenship?
Yes, Your Honor.
Should be a form for Your Honor. I was running a credit calculation. I calculate 6 days across 4 different
So-
states.
It looks like you missed a court date in just a couple days ago.
Yeah.
And now I'm looking at a statement of defendant on plea of guilty, which tells me you intend to plead guilty to simple assault, domestic violence related. Is that your understanding of what's happening?
Yes.
Do you understand? When you plead guilty, you give up all the rights contained in paragraph 5 of your plea form?
Mm-hmm.
Maximum you can receive for this is 364 days in jail and a $5,000 fine.
Yeah.
City's going to recommend 364 days in jail with 358 suspended, credit for 6 days served, have no criminal law violations, and comply with any existing no contact order, don't possess a firearm. And then it says anger management or DV evaluation per court. I'm not sure exactly. Does that mean that she can choose that? What's the city's recommendation there?
That is an interesting recommendation, Your Honor. I think it was put together by another prosecutor in my office. At this point, we're putting it to the court, suggesting that the court order her to do one or the other, and we'll defer as to which.
And then, do you understand that recommendation, ma'am?
Yeah.
And there's also going to be a no contact order that you're going to need to comply with also. Do you understand that?
Yeah.
And what's the relationship between you and the protected party?
He's my child's father.
I see.
My estranged husband. Ex-husband.
Do you understand I'm not required to follow that recommendation?
Yes.
Anybody make any threats or promises other than what's contained in the plea recommendation to get you to plead guilty?
No.
Paragraph 11 of your plea form says, on January 3rd, 2024, you intentionally assaulted your boyfriend by hitting him, and this occurred in Lacey. Is that correct?
Yes.
Did you review this whole plea form with Ms. Alt there?
Yeah.
Any questions about any of it?
No.
I'll accept your plea, enter a finding of guilty, enter a finding that the plea was made knowingly and voluntarily. We'll proceed with sentencing. Mr. Sharp, anything further?
I'd say would ask that the court adopt the recommendation. It's agreed between the parties. That's it, Your Honor. Thank you.
Ms. Alt?
Your Honor, I would also ask the court follow the recommendation. This case is almost 6 months old. She is taking responsibility. Will be obviously getting the treatment, so I think it's appropriate. I would ask the court follow it.
Anything you'd like to say, ma'am?
No, Your Honor.
Say that again, please.
No, Your Honor.
How old's your child?
He's 3.
Is there a plan in place in terms of parenting plan, how this is all going to work out? I mean, this.
We had an amended no contact order because of the parenting plan.
I see. And then who's the primary custodial parent? Where does the child spend most of its time?
It's been with his father because I don't have a place currently.
And Mr. Sharp, within the no contact order, when it says other restrictions, where that sort of thing is written in, that's blank. Was that in the temporary? Was that in the predisposition order?
I'll check, Your Honor. There were no exceptions in the original order.
Give me a minute. You're listed as a victim in the City of Olympia case. Is Chase the defendant in that case?
He's not, Your Honor.
And I don't see a. Is it Ms. Alt? Are you aware of any sort of parenting plan?
I am not. I'm sorry, this is Miss Langley's case, so I don't have anything.
Go ahead, Ms. Blankenship.
No, sir. I know our divorce case got thrown out of family court, so I might have to refile it.
All right. And then Ms. Alt, you may not be able to answer this question either, but you know, it's kind of an unusual either or treatment recommendation. Did you get a chance to discuss that with her in terms of what her plans are?
Well, I did, Your Honor. My understanding is that it sounds like she spoke to Miss Langley on Monday, or she spoke to someone. I'm assuming it was Miss Langley who went over everything with her. Originally, I wanted to set this for Monday so that Miss Langley could handle it, but she indicated that someone had gone over the offer with her, and that if it was still on the table, she wanted to take it today.
Okay. Well, I'm sure she wants to get out.
Yes, that's usually the case.
So Ms. Blankenship, I'll come back to you. Have you given any thought as to, you know, there's affirmative conditions where it says either or. You discussed that with Ms. Langley, or what are your plans in that regard?
I was either going to take the GP evaluation and then follow the recommendations, or do the anger management classes. But
I know, but I'm wondering if you had a preference, or have you given any thought to what better fits your situation?
The anger management classes.
Okay. And then do you have a plan for how you can go about doing that?
I was going to go get an assessment and get started at PHR.
I'm sorry, Your Honor. Was I muted? I was
If you were speaking, I wasn't looking, so yes, you
Darn it.
were.
That was a lot of wasted breath. During a child exchange, there was an argument. It continued for quite a while and went to his car and then back out of his car. Looks like at one point he was walking away to go get a phone, and Ms. Blankenship threw a ceramic drink tumbler at his head, hit him in the back of the head, and cut his head open.
Okay, so here's what's gonna happen there, Ms. Blankenship. Be 364 days in jail with 358 suspended, credit for 6 days served. So you're gonna get released here later today. It'll be suspended for a period of 2 years. On the condition you don't have any criminal law violations, don't possess a firearm or other deadly weapon, comply with a no contact order. You're not to possess, own, or have under your control a firearm unless that right's been restored. And I'm signing a no contact order. You may do anger management or domestic violence evaluation in compliance with recommendation. Sounds like you have a plan in place to do that. Can you get that going within the next 60 days?
Yeah.
To get that 60 days, there is a no contact order based on what's been alleged. And I'm going to write into the no contact order that you may communicate through text for the purpose of childcare, and that's it. Do you understand that?
Okay.
And what is your last name? It says Blankenship, but then when it pops up here, it's something different. What is your last name, ma'am?
Blankenship, but it's gonna change back to Olson.
That's it for today, ma'am. You'll get released. You're going to be on monitored probation, which means you're not going to have a probation officer that we're going to check and make sure you get that either anger management or domestic violence evaluation in. So you need to get that in within 60 days.
Okay.
You'll get released here later today. Good luck.
Thank you.
Now, the last Lacey case is a motion to dismiss. I wonder if we could just take that quickly.
Yeah, give me a minute. Yes, is the short answer. But I need to finish up with Ms. Blankenship here. Go ahead, Mr. Sharp. Which one is that?
Yeah, based on insufficient evidence that he's moving to dismiss number 1, Mr. Beaver's case.
Will be released. I'll sign a release order. Case will be dismissed.
Thank you, Your Honor. I sent a note to the jail and they're not going to pull him. So thank you and have a nice day.
Thank you. You too. You, Ms. Alt, you're free to go also, unless you have any other cases.
I do not, thank you.
So Ms. Neaton and Ms. Weston and Mr. Seeley, can you folks come on the Zoom call, please? We're going to start with on May 12th. So Mr. Seeley is asking to set this over for 60 days. He says that there's apparently a pending case in Pierce County Superior Court. I will tell you, Mr. Seeley, I'm not really inclined to do that, given I've reviewed everything that's been submitted, including there's what's referred to as an extracted stipulation of facts, which kind of outlines the course of this. Apparently, this has been going on for a number of years. In your request, you'd indicated there's no contact orders in other jurisdictions, including federal court and Pierce County Superior Court. I think I could double check that. Hang on just a second. There's active military protection orders, and there is a no contact order in Pierce County Superior Court. You also say that you indicated that there may be some sort of negotiations or some sort of maybe a disposition in Pierce County Superior Court, but I see that case has been on warrant status for a couple of years, and so I guess given the history of this case, I'm unsure why we can't go forward here today. And plus, even if a no contact order is entered, you know, given the other orders in other places, I'm not sure, you know, how your life would change at all. But go ahead, I'll hear from you. But I'm prepared to go today, and given how long and given the nature, and I've reviewed everything that's been submitted, including the petition and the and again, the extracted stipulation of facts. And so I guess I'll hear from you as to why we can't proceed today on this. I'm going to guess that Ms. Sneeden and Ms. Weston very much want to get this over with here today. Go ahead.
Your Honor, I first would like to address the warrant in Pierce County, Washington. When that case was initially brought against me, I was in pretrial confinement in the military. And because I wasn't able to make it to court because of my confinement, they issued a warrant. And because I was in confinement until May 4th, 2025, that's why there's still an active warrant. And as of the 22nd, so this Thursday, I have a warrant quash hearing in Pierce County District Court.
Okay.
Or Superior Court, excuse me.
Okay. And so how long is that no contact order in military no contact order in place?
The military Your Honor, the military no contact orders are effective until 26 December 2025, when I'm no longer under jurisdiction of the military. And the Pierce County Superior Court, from my understanding from my attorney, is those will be permanent no contact orders issued from the court once the case has a final disposition.
So I guess what's the problem with entering no contact orders here? Because you can never, it's kind of impossible to predict the future. You never know what's going to happen in Pierce County. If the case goes away for some weird reason, then all of a sudden they're left unprotected. And once you get out of the military.
Your Honor, we have a plea agreement on the table. Like I said in my statement, the plea agreement is I'm pleading guilty to one of the charges. And when I plead guilty to one of the charges, the no contact order will be issued by the court. We're just waiting after the hearing to get a court date to sit down in front of a judge and actually sign the plea agreement.
Okay. Well, are you opposing this no contact order?
I would like to make statements. Yes, Your Honor. If 60 days is too much, I would like to request at least another 2 weeks so I can prepare my case. I didn't submit any documents because I was advised by my attorney not to.
Okay. Ms. Sneeden, and then I guess I'll hear from you just because you're on my screen first. Could you raise your right hand, please? Do you swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
You can put your hand down. And then what's your position, first of all, on the request for a set over? And then I'll hear from you on the merits. And then go ahead first on the set over and then stop. And then I'll get Ms. Weston's input.
Okay, Your Honor. Well, first, I do not have a military protective order. Because of these events, I actually was discharged from the military. So there's nothing the military can do to protect me. I'm no longer on active duty service. I would like for this to move forward, and I have a bunch of points that I am ready to talk to you about today, Your Honor, that I've listed.
Okay. Ms. Weston, could you raise your right hand, please? Do you swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
And then what's your position on, again, first of all, the request for a set over?
I would prefer to move forward today, Your Honor. This has been ongoing for many years, as you can see, and I would just like to get this over with.
Are you still on the military? Still in the military?
I am not, Your Honor. I got out of the military.
Okay. And so, Mr. Seeley, I'm going to come back to you. I'm going to hear from both petitioners. This case is, again, this case started in these series of incidents. Does this go back to 2020 or 2021? I'd have to look. I know it's, when did all this start there, Ms. Sneeden?
2021, Your Honor.
Okay. And so I'm going to hear from them on the order, and then I'll hear from you. If you choose not to present information, that's up to you. But given that, again, there's a stipulation of facts in the record, which a lot of it's redacted, but I think I was able to figure out who people were talking about within the context of this case. We're going to go ahead and go forward today, and then I'll make a decision, and then we'll go from there. So Ms. Sneeden, I'll hear from you first.
Okay, Your Honor. So his criminal case that's brought up, I'm listed as a witness for the state. So I'm working with them to provide them all the information, but he said he's pleading guilty. And then in the stipulation of facts, number 1314 is where it starts documenting his retaliatory and violent nature. So I obtained my MPO, and he broke into my apartment as revenge. When I got the CPO, so this is number 18 and 19 on the stipulation of facts, he faked that hostage situation, resulting in Pierce County SWAT coming, which is what his current criminal case is about. And then on page 34 of the exhibits, line 11 through 15, during the military court-martial, I testified about my fear that he would seek revenge by killing me, and he nodded, and this is on documentation. So I kind of just urged the court to go today, because also in the stipulation of facts, it shows that they had hired private investigators to follow us. So no contact orders do not protect us from the extents that they go to find us. He has already been found guilty for 2 counts of stalking, 1 for myself and 1 for Madison. And I guess I'm pleading to the court to protect us, because we really have no protection for the means that he is willing to go to find us.
Ms. Weston, you've previously been sworn. I'll hear from you.
Yes, Your Honor, I think Jacqueline really hit all of it, that there's a pattern of revenge and of threats of violence with Mr. Seeley. Even after all these years, I think that his anger about actions being taken to protect us and to stop him is just proven with the stipulation of facts and everything that is stated in those statements. Those are statements that he wrote, that he admitted to doing. I'm unsure of a Pierce County protection order. I never filed for one. I was never made aware of one. So as far as I'm concerned, I am unprotected right now.
So Mr. Seeley, could you raise your right hand, please? And do you swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Do you wish to say anything? You can put your hand down. Do you wish to say anything at this time? And
Yes, Your Honor.
I will say, before you do that, I want, on the information that I have, what they call JABs, or the Judicial Access browser system, where I can see orders in different cases. Doesn't look to me like there's a no contact order in Pierce County Superior Court right now.
Yes, Your Honor. I have paperwork issued from the court when I went to my arraignment that says I will not have any contact with either Jacqueline Sneeden or Madison Weston. And that was from my arraignment, which should be able to be viewed from your system.
Okay, well, it's that's probably on the release order, which is a condition of release, is something different from a formal no contact order. So it might be a condition of your release you're not be able to, but that won't show up in a database as a formal no contact order.
Okay. And
Which may be a distinction without a difference to you, but to me, there is a difference on that.
Okay. And then back to the MPO, the stipulations of my release for my discharge paperwork. It also says that my MPOs are still in place and I will have no contacts with my victims. So there's still no contact orders for the military side, which I'm under their jurisdiction until 26 December 2025, in which I have to report to a federal probation officer as well, which I listed her contact information in the paper that I submitted to the court, Your Honor.
Okay.
Also, I would like to bring up that in the stipulation of fact, it shows that I did not break into Jacqueline Sneeden's apartment, that someone else did. All I did was return a firearm. And when it came to the court transcripts for my court martial, I will still object to that. I did not nod my head at Miss Sneeden to, I don't know what the word I'm looking for is, to annotate that I was going to come after her for revenge. I still object to that. She also did say it's going to be a who shoots first, so I take that as a threat, and I did file that in my first appeal from my military court as taking that as a threat, as it's going to be a who shoots first scenario. Those are words coming out of her mouth. Also, during my pretrial confinement, Miss Sneeden and Miss Weston felony vandalized my vehicle. I wasn't able to submit pictures to the court, but while it was in before it was in CID custody, immediately within 24 hours after my arrest, my window was broken out. There was a hatchet taken to the side of my door. My mirror was busted out, and it was over $14,000 worth of damage done to my truck after I was arrested. And only the victims and my chain of command in the military knew where I was staying, because I was not staying in my home. I was staying in a different barracks on post with a different unit. And like I said, only Miss Sneeden and Miss Weston and the chain of command knew where I was staying.
Your Honor, I'd like to speak on that.
Okay. And while I wait till he's done, anything further there, Mr. Seeley?
Yes, Your Honor. I noticed that both in Miss Sneeden and Miss Weston's statements, they said that it had been 2 years of harassment. I would like to object to that. I started harassing them in July of 2021, and I stopped harassing Miss Sneeden, and it's stated in the stipulation of fact with dates for February 2022 and March 2023 for Miss Weston. And it says in the stipulation of fact that one of my family members, aka my mom, started harassing these two. So I was not harassing these individuals for 2 years. It was only a period less than 8 months and 6 months for the harassment. And then she claimed that I was harassing them or stalking them. I think it was Miss Nina said that in her statement, said that I was still harassing her and stalking her during my court martial, but I was in pretrial confinement. I was in jail. I could not stalk her. And I believe that to just be a blatant lie.
Anything further?
As of right now, unless anything else is brought up, that is it for now, Your Honor.
Okay. Ms. Sneeden, was it Ms. Sneeden you wanted to address that?
Yes, Your Honor. So first of all, I did not know where Mr. Seeley's truck was, so that was a lie. I have never damaged his vehicle, nor have I wanted to go around him. When you're a victim of stalking and the harassment and the violence that we were, you would not want to go near anything of theirs because you don't know what's going to happen. He also took the part of the court martial out of context. When I was asked, how do I think this will end? After I said that, I testified that he nodded, and that's on the record. I said that I think he will kill me, and I would try to defend myself if he were to break into my home. The last thing I would like, what did he, he just said I was blatant lying. I have not lied on record, Your Honor, is the point. I never damaged his vehicle. I don't know where these accusations are coming from. They're baseless. And it goes to show that he is still angry. And I think it emphasizes his history of retaliation. And my voice is starting to shake because I have dealt with this for years and I know his anger. And it's just showing that none of it's resided, Your Honor. If anything, we are definitely still in danger.
And Ms. Weston, did you wish to have anything to add or no?
Yes, Your Honor. As far as the damage to his vehicle, this is the first that I'm hearing of it, and I would really like that stricken from the record because there's no proof that her or I had anything to do with this. As I said, this is the first I'm hearing about it. I had no idea where he was staying and didn't know that his truck was vandalized. This is 2.5 years later, and I'm just hearing about it for the first time. So I would like that to be taken out of consideration. Also, the court-martial transcript clearly states that, and I think it's in the testimony, maybe not the stipulation of facts, that his mother was harassing us on behalf of him, as well as the burglary to our home was on behalf of him.
So Mr. Seeley, I'll give you the final word. Anything you'd like to say at this time?
Yes, Your Honor. I do not have any current ill will towards Miss Needham or Miss Weston. I have no interest in hurting them, stalking them, anything. I understand why they're upset. I did my time. I pled guilty to the charges for the military. I accepted the first no contact order. The first no contact order wasn't violated. I understand where they're coming from, but at the same time, I have no interest in Miss Needham or Miss Weston. I understand that they fear for their life, but there's no reason for them to fear for their life. As it states in the stipulation of fact, all I wanted to do was make them fear, not actually hurt them. I have no violent history, no violent past. I've never actually physically threatened anybody. So I don't know where they're getting that I'm physically aggressive, because I've never hurt them or anybody, and that's court factual. As far as my vehicle goes, I still stand by that statement, because they were the only two that knew where I was, to include the chain of command, and I know the chain of command wouldn't damage my vehicle, and it just so happened that within the first 24 hours that I was arrested, that my vehicle was damaged. Because if I was able to submit documents, I would be able to submit pictures, the pretrial confinement magistrate's notes where the CID officer says that my vehicle was found damaged. And then there's other documentation that I would submit also, that Miss Needham said that she didn't, they're blatant lies that I said that she made. It's right in front of you, Your Honor. She's making statements in her, she's making statements on her individual documents that contradict what the stipulation of fact from the court-martial says that she had to agree to in order for the prosecution to sign. So there are discrepancies.
Okay, so here's where I'm at on this case. Give me just a second. So these aren't criminal cases. These are civil cases for anti-harassment. If someone's harassing or somebody else, they can come to court, ask for an order for no contact. Unlawful harassment is defined as following: as a knowing and willful course of conduct directed at a specific person that seriously alarms, annoys, harasses, or is detrimental to such person, and that serves no legitimate or lawful purpose. The course of conduct must be such as would cause a reasonable person to suffer substantial emotional stress, and must actually cause substantial emotional distress to the petitioner, or in these cases, two petitioners. Course of conduct is just defined as a pattern of conduct, composed of a series of acts over a period of time, however short, evidencing continuity of purpose. In this case, I'll make the following findings. Contained in the record, there's a timeline of events outlined by the petitioners. This all began in July of 2021 with Mr. Seeley, Ms. Sneeden, Ms. Weston were all in the military. Ms. Sneeden was in a position as a victim advocate through some fairly sophisticated manipulation, deception, impersonating other people. Mr. Seeley began a series of contacts, a course of conduct, which really had no other purpose other than to frighten, intimidate, or harass Ms. Sneeden. In fact, Mr. Seeley, one of his comments, I was kind of struck by your comment when you said, well, I didn't harass them for 2 years. I only harassed them for 8 months. shouldn't have been harassing them at all. 8 months is, I'm not making a finding for exactly how long this went on, even though you may have stopped. I mean, the feelings and the reaction to Ms. Weston and Ms. Sneeden is going to continue. And based on their body language and demeanor, it's probably continuing till now. You can say, well, they don't have any reason to fear me and all that sort of stuff. But I understand why they would continue to feel that way. You have said that you bear them no ill will or don't want any contact to them. That's good. I hope you mean that. But I am going to enter orders today. And these civil orders, they can't do them indefinite. Typically, the default position is a year. But in this case, given the level of harassment that I've seen that's contained in the file, both with the stipulated extraction of facts, I'm not sure I said that right, combined with the statements of Ms. Weston and Ms. Whedon, combined with the transcript of the military I guess tribunal they call it. I'm not sure they call that. That was a hearing of some sort or a trial within the military. I've never been in the military. I'm not sure specifically what that was called, but the order is going to be in place for both of you are going to be in place for 5 years. And so, and Mr. Seeley, again, this should be, I'm hoping this just makes it easy for you. It draws a bright line. You say, well, there's an order. They say, well, we're not sure about that. I don't see an order in Superior Court. I tend to, what Ms. Sneeden says makes a lot of sense, that if he's not in the military order may not bring much protection or comfort for her, but there's going to be an order here. You understand that?
I understand, Your Honor.
And you're not to have any contact with them, not engage in stalking, don't come within 1,000 feet of them, their residence or place of employment. And they're just not in any way a part of your lives. Do you understand that?
I understand, Your Honor.
And, and I'm also sensing one thing that maybe is, in some way, it seems to me like you're kind of trying to shift blame from yourself to them. But this order's in place. You spent time in the military facility and are being prosecuted in Pierce County Superior Court because of your actions. And I hope you understand that. These two individuals are not to blame.
I understand.
And so the order will be the order will be in place for a period of 5 years. And like I say, and you can get copies of this. All of you can get copies of this, or actually, do we have their email to send it to them? The petitioners will have an email. It'll get sent to you at the email that you provided. And if we have your email, Mr. Seeley, you'll get a copy of it also.
Okay.
Your Honor.
And we do have that. And then you folks are free to go. You'll get a copy of the order later today. What's that?
May I ask one question, Your Honor?
Yes.
Will this also include no third-party surveillance?
Yeah, and that includes third-party contact. And then that's directly or indirectly. So yes, is a short answer. If you have someone on your behalf bothering these people, and I understand that may be disputed, but nonetheless, if you have anybody do anything on your behalf with regard to these two individuals, most courts, I know I certainly would consider this a violation of the order. Do you understand that, Mr. Seeley?
Yes, Your Honor.
It's done with these folks in any way, shape, or form.
I understand, Your Honor.
Great.
Freeman versus Ferris, a small claims case. Small claims means we are trying to do this without any attorneys being involved. Nobody is represented by a lawyer. You're also asking for this to be resolved here in front of me, as opposed to something like having a jury trial. It'll just be me deciding it today. So if both parties are ready and able to proceed, the first thing I would do is swear you both in. So go ahead and raise your right hands. You swear or affirm testimony you give here today would be the truth, the whole truth, and nothing but the truth.
Yes.
I do.
All right. So I did get some information about this ahead of time. So essentially, Ms. Freeman rented out a dumpster trailer to the business there, the Farm Deli, with understanding that that was going to be $100 for every week that it was used. What I didn't see, Ms. Freeman, who'd you actually make that deal with?
John Blue was, I believe, her general contractor. I didn't really make a deal with anybody, I guess, but John was the person I spoke with. But the problem is that John won't pay me. So, and he directed me to Christine Ferris for payment, as you can see by a text and an email there.
And then when you did get it back, let's see here, what was that? Maybe 10 months later or so, there was some damages to it. 2 tires needed to be replaced, a hydraulic pump replaced. That $997, you actually paid that, or that's just the estimate you got to get it fixed?
No, sir, I had to, it's a working piece of equipment for my business. I needed it fixed. I paid for it.
And the out of commission for 6 weeks, you did not actually ask for any of that. The 5195, that's just the 10 weeks or 42 weeks of $100 a week plus the $997, right?
Yes, sir.
All right. So Ms. Ferris, I'm going to give you an opportunity to explain to me why it is you don't think that you would owe this money.
Yes, thank you, Your Honor. I'm just a little nervous. I've never done this.
First of all, let me tell you, this was a phenomenal price. For you to have had a dumpster where 10 loads are going out would have cost you just thousands and thousands more dollars than $100 a week. This was a sweet deal. That's why I'm a little confused why you aren't just sort of happy to pay it and be done.
Absolutely, and I understand that. So the original agreement was made between her and Johnny Blue, my contractor, and he borrowed it in December when they had some projects going on together. So I assumed that she was being kind to him. I had nothing to do with this. I had actually bid out getting construction dumpsters. So I do understand the price of them. And we used it for a few weeks. We hadn't even gotten our building license yet. So he did a little bit of demo with it, and then it sat parked for several months. And I said, doesn't Lisa want this back? And he said, well, the agreement was $100 a load. And I didn't double check with Lisa because the deal was between the two of them, and he's my contractor. So I'm not double checking everything.
Let me just, and I just want to intervene for a second here. All of that may be true. But the way that we would remedy that is then you would turn into a plaintiff and this gentleman would turn into the defendant, where you would be saying, hey, you're acting on my behalf as my general contractor. You're making deals that I am either not aware of or not agreeing to. But at the end of the day, the actual service provider, the person whose dumpster that was or who does that service, gets paid. Now, whether that should come from you or him, that could very well turn into a small claims where you sue him. But the first things first, as the business owner who engaged a general contractor, the buck would stop with you in terms of Ms. Freeman getting paid. And then I understand if what you're saying is, hey man, I did not think that was what was going to happen. I got, sort of led astray by my general contractor. Then you may turn around and be the one who sues him. And I wish we had that sort of middle party here, but we don't. But Ms. Freeman doesn't need to sue him. She can sue you as the person he's acting as the agent for. Does that make sense?
Yes, it does. When the invoice was sent to me, I shared it with Johnny, and he said, this is absolutely not what we agreed upon. Write me a check for the original amount, and I will work out the details with Lisa. I'm the one that was dealing with her. I will take care of it. So I wrote him a check for the total amount that we originally agreed upon, and I added $300 to it for damage to tires.
So how much was the check that you wrote? How many loads did you think you were paying for?
for 10 loads. And
All
so
right.
it
So
was
you
a
wrote a
check.
check for $1,000 and then 300 more to throw towards the damage.
Absolutely.
All right. So we're not on totally different pages here. We're just in disagreement about what the actual dollar, whether it was per load or per week. But here's the situation, Ms. Freeman. This is just something you own and you do it as a side thing, or this is your method of making money?
It's a method of making money. I own a property management company. The trailer was brand new when.
What is the going rate that you rent it out for?
$100 a week, which, to your point, Your Honor, a trailer like that in Holland rents for $100 for 4 hours. It's $140.
So my question is, do you ever do it by load? See, by load doesn't make a lot of sense to me, because load might be wear and tear on the trailer, but really what Ms. Freeman is, it's by time. You know what I mean? If the next person wants to give her the same amount of money for the next week, so whether you take 1 load or 10 loads in that week would just be how efficiently you're using the $100. To pay by the load doesn't make nearly as much sense as to pay by the time that you have the dumpster where she's not renting it out to other people. That's why I'm not saying that isn't your understanding, Ms. Ferris. We'll give you that. That's your understanding. I'm just saying that doesn't make a lot of sense from your general contractor to think that he's paying by the load. In other words, if I take 2 loads in one day, and if I take 2 loads in a year, I owe the same amount of money? That doesn't make sense, right?
No.
It makes sense that you'd owe a lot more money holding it at your house for a whole year, even if you only took it to the dump one time, than if you only used it for 2 days but took it 5 loads. You see what I mean? It doesn't really make sense to go by load. It makes a lot more sense to go by time on the clock, where I can't rent this out to somebody else. The load would be wear and tear. I could see how you may have a sort of a supplement to that, that if it was over a certain amount of loads or something, then you may add something for that. But time makes a lot more sense than loads. Do you get where I'm coming from with that?
I do agree with you on that. And to that point, I would say that I thought it was a verbal agreement between 2 friends, because Johnny Blue and Lisa Freeman have a long history of doing projects together, and Johnny was actually working on projects for her at that time and flying down to Florida regularly, working on her hurricane damaged home and driving up north to her vacation home and working and taking breaks from my project to help her out. So my assumption, which in retrospect was probably not smart, we should have gotten it in writing, was that they had a verbal agreement as friends that, hey, you're not using this trailer right now, so I can use it and get some money back to you. And there were periods of months where the trailer was not in use and it was sitting on my property. And I said, Johnny, should we get this back to her? And he said, no, it's the dead of winter. She's just gonna have to be plowing around it in her parking lot. So don't worry about it. And they talked and worked regularly, so I stayed out of it completely.
And to tell you the truth, I don't really even blame you for not taking action above and beyond what you've just explained. That's why I said that at the end of the day, this may very well turn into, after today, you become a plaintiff. But here's why I would sort of disagree with how you're viewing the case. First of all, Ms. Freeman, let me be clear. $100 a week, was that the friend price, or that's what you charge me to rent this?
No, that was, and actually, Your Honor, you need to understand, I'm sure Saugatuck was a small community. I was also a friend with Chris Ferris and was a frequent person in her business in the deli. And so it was, I guess, just a gesture of good faith to both John and Christine that I give them a good deal like that. I would never have said $100 a load. That is ludicrous. I would have never known how many loads John Blue pulled to the dump. Plus, he way overweighted it. He put way too much weight in it. And that's how it correspondingly ended up.
That's why the hydraulic pump needed to be replaced, I'm assuming. All right. So the other thing is that, lots of times when there's this sort of disagreement like this, and I'm explaining sort of how things work even if it wasn't you two in this particular scenario, where one person is the the service provider who has a business doing this, and the other person is the person who's just paying money for the service, and you don't get it in writing, I will usually always spank that person, Ms. Freeman, and it will be well, here's your tough lesson about getting things in writing, even when you're dealing with friends, because it's business. And lots of times, what I would do in this scenario is limit. I would always say that you're going to end up with more than $1,300, all right? But I may not give you $5,195 because your flaw in all this was to not get it in writing. But the reason why I'm not necessarily going to do that here is, at the end of the day, for the amount of time that the dumpster was used and how the dumpster was used, this price is still just a really good price. And so I don't really feel the need to also cut into that. If anything, I think Ms. Freeman lost money on this, where I don't know, how many of these do you have?
Just one. And I literally.
And do you have, I know it was brand new for you,
yes.
but do you have any idea how often it is this is going to see? I mean, what was the timetables here? Was this like December of last year to like October of, I mean,
the year
in
before.
other words, how long have you had it back after it got fixed?
Well,
From then till now.
About a year. About a year.
All right. How many times have you essentially rented it out and with a person and made money?
I'm not renting it really anymore. I'm just using it for my own property. I lost that trailer for an entire summer, and I'm a property manager in Saugatuck. That was a big loss for me, for my business. I had to rent other ways to move things because I didn't have my trailer. So I have not done that again. I knew Christine, no John, never thought that this would ever turn into this kind of a situation. I did it as a goodwill gesture. So I use the trailer for myself.
Essentially, what I do want to explain the also, Ms. Ferris, is I understand that you even said to yourself, okay, well, I got to tack some on there because, it got flat tire, there was damage to it. Did you actually see the invoice, the $997 invoice? I know that was sent to court. I don't know if you ever got a chance to see it.
So I got an email so Johnny Blue told me not to respond to Lisa because he was taking care of it. And he said if I said anything to her that it would inflame her. And in retrospect, I see that not responding to her inflamed her, and I should not have listened to Johnny. So I did make a mistake there. But Johnny told me he would handle it. And when I gave him a check, he cashed it, and he told me that he would get it to her, which never happened. And then after
Ms. Freeman, you never even got this $1,300?
Oh no, I have, Your Honor, I've not gotten a penny. Not a penny.
All right. So ladies, I'm starting to see what the problem here is. The problem is a third party that's not sitting in front of me, because that probably would have gone a long way to, if it was promptly delivered and say, oh, this is a big misunderstanding, here's what we did. You guys probably could have come to some third position that, everybody was slightly unhappy with, but everybody could live with. I see why Ms. Freeman is saying, I guess I got to go to small claims. I'm just getting totally bamboozled here. And Ms. Ferris is like, I thought this was an issue, a non-issue, and then a little issue that I took care of. And then it turns out I'm sitting here in court getting sued for $5,000. So the reality is I want you to sort of understand when the dust settles here that I would make this decision for what I would say is fair to do here, 42 weeks at $100 a week, plus the $997 that it actually took to get the trailer back to the shape it was in before it was rented out. But Ms. Ferris, I'm not giving you legal advice, but you owe money to Ms. Freeman after today that really you could turn around and retrieve a good portion of that from this contractor, because that, first of all, if anyone between Ms. Ferris or what's his name again? I'm sorry.
Johnny Blue
would have understood that this price per load doesn't make a lot of sense versus a per week. That's how everybody rents out trailers, is time, not necessarily loads. because what Miss Freeman is also mentioning is something that comes up with loads all the time. The trailers, you know, it's rated for 5,000 pounds. You take it to the dump, you put 7,000 in it. Like they fine you for that. They charge you extra for that because, you know, load is a separate thing than time, but it's usually always time. And the fact that you're testifying to me that, hey, I wrote a check to try to address this issue. And then you're hearing now that it never went to Miss Freeman. That's a problem, but that's not a problem with you. That's a problem with this gentleman. So we need to get to the bottom of that.
There were months where the trailer was sitting empty, and if Miss Freeman had ever asked for it back, I'm
But
really
here's the
sorry.
thing, though, Miss Ferris, she doesn't know whether or not you guys are just continuously using the trailer, every couple of days to renovate whatever you're renovating. That's not really her to say, hey, are you done with it? It's more you to say, hey, now we're done with it, right?
It's my mistake assuming that my contractor was managing the equipment he rented. Well, he was also working for her. They were in constant communication. Johnny even showed me communication from Lisa on his phone, like, hey, can I get the trailer back? And Johnny said, yes, it's full. I'll empty it and bring it to you in the morning. Johnny showed me that a year and a half ago when this was happening. And he said, that's the only time Lisa ever asked for it back. And I can't prove that because Johnny's not here. No.
But even between your general contractor and Miss Freeman, it would be more for general contractor to say, okay, we're done with it. Or now the other thing too is maybe you don't wait till a whole year goes by and then say, okay, well, not quite a year, but 42 weeks. You could say, oh, okay, how about I bill you for 20 weeks because it's been a minute. Those are also sort of, business decisions. I'm sure if you were strangers, Miss Freeman would have rode this a little tighter. I think she probably, was a little more loose with this because, of course, it was, everybody knew each other. It's a small town and it's not like it was a ton of money, $100 a week for business owners. But anyway, what we need here is someone to come in, make this decision. I am going to decide this was 5,100. It's actually, I think 97. You asked for 95, but I got to do it by what you're asking for because that's what Miss Ferris was on notice for.
Yes.
5,195 in damages. The only other expense, Miss Ferris, just so you understand, Miss Freeman had to pay certain monies out of pocket to get here today. She had to pay a filing fee with court. She had to pay to have you served. That $82, she's also able to collect that. So I just wanted you to understand where that other $82 comes from. And then, like I said, I don't know how many times I could say this, but this doesn't have to be the end of this. What I've decided now, you both would have a chance to appeal where either one of you could say, I don't agree with what just happened there. I want to go to general civil with this in front of the district court judges. To do that, you must ask for that within 7 days of today's date. And you must ask for that in writing. So do you understand your rights on appeal?
Yes.
Yes.
And just because this decision went against you, Ms. Ferris, does not mean that you could in turn rope in a third party and sort of, straighten it out a different way where you're the plaintiff and not the defendant. But just so, we understood that. All right, Mr. Grable, you want to take yourself off mute so I'd be able to hear your responses? There we go. This is file 25-01136-SC, Freeman versus Grable, a small claims case. Small claims means that we're here trying to do this without involving attorneys, so nobody is represented by a lawyer. We're also asking for this to be resolved here in front of me, as opposed to either party asking for a jury trial or anything like that. So first things first, if the parties are ready, willing, and able to proceed here in front of me, I would swear you in. Please raise your right hand. You swear or affirm any testimony you give here today would be the truth, the whole truth, and nothing but the truth?
Yes.
I do.
All right. So first things first, you guys don't know each other, right?
No.
Miss Freeman, who is it you were trying to send the Zelle to?
Well, interestingly, Mr. Grable lives in Stevensville, and the gentleman that I was trying to send the money to, just with a pure amount of irony, I think, also is in Stevensville. He owns a company called Dixon Motor Works, and his name is Scott Dixon. And his number is 1 digit off from Daniel Grable's phone number, to which I Zelled the money.
Okay. So here's the thing, is my understanding of the information I have at this point. $1,500 Zelle went to, and Mr. Grable was not supposed to go to Mr. Grable. At some point in time, you realized that, Ms. Freeman, and then you got real lucky because you understand if Mr. Grable was in Arizona or something like that, this probably wouldn't even be enforceable. It is enforceable in small claims because you're both here in Michigan. Mr. Grable, so like I said, you don't know Miss Freeman, right?
Correct.
And then so money shows up in your Zelle. What did you think it was for?
So funny enough that you just said that. So the week before that the transaction showed up in my account, I had actually just moved to Arizona for the winter.
Yeah, I completely picked a state. I'm not trying to imply I somehow know something about you. I could have mentioned any of the other 49 states, but
that was random. But so I just signed a lease for the winter, and to pay my landlord, I was supposed to Zelle him. And this was my first time using Zelle as well. So the week before this happened, I just signed up through my bank, sent money to my landlord. And even I was kind of like, oh, that was a little too easy just to send money to a number. And so then a week later, this shows up, and I was just kind of like, whoa, like, is this like fraud? Like, what happened here? And so I saw the money in my account. I was talking to my family who was back in Michigan, called my bank. They said, yeah, we've heard of stuff like this kind of happened before. They kind of told me to be alarmed of fraudulent action. And so
you should.
Yeah. So they said it was on me if I wanted to reach back out to Miss Freeman or if I wanted to just let it go for that moment. And so I chose to ignore the matter. And then she reached out a couple months later and I ignored it again. And now we are here.
Okay. So just a couple of things. Yeah, that's a real dumb way that Zelle does it. I don't know if you're familiar with any of the other systems. Either of you do Venmo?
Yep.
Yeah.
All right. Because Venmo, there's some name that somebody picks, right? But to make sure that's the right person, the next question they ask you is, and what's the last four of their phone number? So that this cross-wired thing doesn't happen. But for somebody to, type in a number and then they just fat finger one digit, I mean, can happen. But Mr. Grable and Ms. Freeman, I want to maybe take a little longer to explain my logic here so that we're not sort of thinking there's anything nefarious going on in Mr. Grable's end. There are a lot of what they call little phishing schemes where someone will essentially, it looks like they sent you money. And they do something where they want you to pay it back. And then before it actually clears their bank that their money is actually taken out the first time, you've already sent them money back. So Mr. Grable, I think it's actually the smart play to sort of just pause and see where this goes. But I think that now sort of, a little bit down the rabbit hole here, what we're seeing is, yes, it was just a mistake that you got Zelled this $1,500. And now I'm assuming you're still sitting on the $1,500.
Correct. Yeah, I've not touched the money. It's still in the same.
And my job in small claims is to do what's right and fair. And what would be right or fair is to order that you would pay a money judgment of $1,500 to Ms. Freeman. Does that make sense to you?
Yes, it does.
All right. So here's the only other thing I'm going to do on this that is a little unusual, but I think is even the more fair thing to do, right? Normally, when I make a decision, it would be for damages. That's the $1,500, but also costs. In other words, Ms. Freeman, out of her pocket, had to pay money to file this case against you and to serve you. She paid $62 to do that. Now, normally, she's able to recover that. It would be $1,562 that you would have to pay to her. Everybody's on board with that, right? But here, I think Mr. Grable is just making what I would call, cautious decisions. I don't necessarily want to make him pay more than the $1,500. And Ms. Freeman, I think if you're getting your $1,500 back, $62 is a completely fair amount for you to have, fat fingered one digit off. All right.
Agreed.
So I'm not going to order costs in this case. I'm just going to order the flat 1,500 that you would pay to Ms. Freeman. And then as soon as you do that, this judgment will be satisfied and over. I do still need to inform you that you do have the right to appeal either party. If you think that my decision is not right, you can appeal this within 7 days to the district court, but you must do that in writing. And then after 7 days, your option to do that is done and my order would stand. Everyone understand their rights on appeal?
Understood.
Yes.
All right, then I'm going to go ahead and release parties. You'll both get a notice in the mail. You don't have to wait for that. You can wait for that. We do expect that the parties would take care of this themselves, i.e. get in touch with each other and, send the money, maybe over Zelle, maybe not, or maybe some other way, whatever you decide. All right.
Fair enough.
All right. Thank you.
Thank you.
Thank you.
Ms. Freeman, that's what we call a good day in court.
Yeah, I feel a lot better.
Ms. Alexander.
Continue on Southwest Freeway for half a mile.
I'm here. All right, Ms. Alexander, we're not doing this until your client gets some clothes on. So I'm putting you at the end of the docket. Sarah, put him back in the waiting room. Move on to the next case.
Well, I'm in the
All right, Reams. Alexander, can you hear me?
Yes, Judge, I can hear you.
All right, your client now has a shirt on. All right, we're on the record in 24 CCR 238220, State of Texas versus Jacoby Dante Reams. Ms. Alexander, if you would give the court an update on this case.
Judge, I've spoken with my client. We were originally set for a plea. When we went over the paperwork, Mr. Reams decided that he did not want to take the plea, and so we were moving forward with the scheduling order of the court for a trial.
Okay. Pretrial conference will be held on August 7th at 9 a.m. That's an in-person docket. So, Mr. Reams, you will need to be in my courtroom. All right, Ms. Alexander, well, state anything further you want to add to the conversation.
Nothing further. That is an accurate depiction.
Okay, very good. Ms. Alexander, anything further?
So, Judge, I am due to have my baby July 10th, and so I am not sure about.
Congratulations.
Thank you, Your Honor. I think I'm okay for the trial date. I'm just not sure if I'm going to be released yet for the pre-trial.
Yeah, that's going to be that'll be too soon. Can I get you and your client to come into my courtroom maybe tomorrow morning? And I can get y'all to sign a new docket control order, pushing it out a little bit.
Let me check for tomorrow. 3rd. I have one fugitive matter. That should work, Judge. Mr. Reams indicates that he works during the day, so I'm not sure. That's why he said he didn't have his shirt on. So if he's online, can we verify that he's available to come in the morning?
Mr. Reams, can you be in my courtroom at 9 a.m. tomorrow morning?
9 a.m. Yes, sir. I can be there. I was there today at 9 o'clock in the morning.
You were there. You were here today?
Yes, sir. I had showed up 9 o'clock in the morning because I had got a text to show up today, May 22nd, at 9 o'clock in the morning, and I had showed up, and the man told me that I had a 2:30 Zoom. So that's why I'm on it now. Okay. But I didn't know, so I had went back to work. I had got out of work early. So I go to work at 4 o'clock in the morning. So I got off around 8 o'clock, showed up at the court at 9. And then so when he told me I had a Zoom at 2:30, I just went back to work and I got out of work at 12:30.
Not a problem. I appreciate you being prompt and trying to be on court on time. but 9 o'clock tomorrow morning will work for you, Mr. Reams?
Yes, sir. It's good.
Okay, we'll see you tomorrow morning. Ms. Alexander, I'll see you tomorrow morning. We'll enter a new docket control order, pushing everything out a little bit for your due date.
Thank you, Your Honor.
Congratulations again.
Thank you.
All right, y'all are free to go.